Very good evening, everyone. Quick audio check. Am I audible? Am I visible to everyone? Before we begin with the live session, let's have our usual AV check. Yes. Can I have a response? I hope I'm audible and I'm visible to everybody. Yes. Chalo. Good. I think I would be audible and visible. Chalo, great. Then a very warm welcome to everybody. Today, we at Clat Possible are going to be discussing what has been in news, a very hot topic, burning topic in the past couple of weeks since the time it has really been introduced into the parliament, right? So we're talking here about the Bharatiya Sakshya Bill, right? Bharatiya Sakshya Bill, जो कि replace करने वाला है हमारी Indian Evidence Act को, right? So today we will talk a little about this bill. उसके बाद हम कुछ questions, passage and questions इसके ऊपर solve करेंगे, ठीक है? चलो, then just give me a go ahead, give me a hi in the chat box, and let's begin. Okay, chalo. I think we can begin. Okay, now, when we are looking at the Bharatiya Sakshya Bill, now, अब ये भारतीय Sakshya Bill जो है, what exactly is it? It is a bill which is going to replace your already existing Indian Evidence Act. Now, let's first have a quick idea about what the Indian Evidence Act is, why is it relevant, and also how this bill is not one bill that we are talking about as in one thing which is being replaced or one bill which is being brought about. Rather, there were a group of three, right? I'm sure all of you who are here to listen to me and be a part of this particular live session would be aware कि भाई ये इकलौता एक बिल नहीं है जो कि इंट्रोड्यूस करा गया था, right? The Union Minister, Mr. Amit Shah, he had introduced, in fact, 3 bills in the Lok Sabha on the 11th of August 2023, right? There were 3 bills which were introduced. These are known as the 3 major criminal laws of our country. अगर हम अपनी country की criminal laws को देखेंगे, the major criminal laws of our country are represented by these 3 acts. You have the Indian Penal Code, you have the Code of Criminal Procedure, and you have the Indian Evidence Act, right? So these 3 are the major criminal laws of our country. Now, all the 3, there is a proposal by the union government wherein they are going to replace them with 3 new acts. ठीक है? सिर्फ उनका नाम ही नहीं बदल रहा है, but there are certain amendments which are being made to the acts. But just remember one thing, just because the name is changing so drastically, I'm like from Indian Penal Code, हमारा जो substantive law है, हमारा IPC, Indian Penal Code is your substantive law on crime, which actually tells us कि भाई theft क्या होता है, dacoity क्या होता है, murder क्या होता है. So the substantive law of our country, IPC, if it is going to be replaced by something known as the Bharatiya Nyaya Sanhita, इसका ये मतलब नहीं है कि हमारा जो IPC है ये पूरा redundant हो गया है या ये पूरा का पूरा खत्म हो गया है. The only thing which is going to happen is, yes, there is a sea change so far as the name is concerned from the anglicized names. मतलब ये पूरा exercise name changing का is one of the major reasons that is being quoted कि भाई ये colonial era का हमारे पास एक gift था, इतना anglicized नाम है ये. Instead of that, हमारे Indian roots से related नाम होना चाहिए. That is why they are saying that भारतीय न्याय संहिता, जो कि एक संस्कृत नाम है. Even though there's a lot of criticism on this, that the name is quite a bit of a tongue twister, and the fact कि ये जो नाम है ये हिंदी, it's more Hindi oriented, but so far as the government is concerned, government का कहना है कि बॉस ये तो हमने संस्कृत के बेसिस पे नाम रखा है, right? So this भारतीय न्याय संहिता is your IPC. The name has sees a lot of change, but always remember name में जो change है वो act में इतना change नहीं है, right? So far as the IPC is also concerned, there are new provisions which are added, certain provisions which are deleted, but मोटा-माटी जो हमने एक्ट अभी तक IPC के जो basic concepts होते हैं, they still remain the same, right? So murder is murder, theft is theft, robbery is robbery, you know, all those basic concept, hurt, grievous hurt, kidnapping, वो सब वैसा ही रहेगा जैसा आपका IPC में था, right? Of course, there is going to be a change in the index. There's reshuffling and shuffling of the index, and there's certain new offenses which have been added. जैसे mob lynching हो गया, वो add करा गया है. So things like that. There's certain offenses which have been added, certain offenses which have been deleted. कुछ चीजों की punishments increase हुई हैं, कुछ चीजों की punishments घटी हैं, but overall basic concepts फिर भी same हैं. So those of you who are thinking that maybe if I'm preparing for CLAT this year, do I then of course I'm studying the IPC, but if I'm preparing for the CLAT next year, does it mean that, you know, if I have studied a little of the criminal law, it's not going to be of use? No. Everything is still going to be of use. Your IPC basic concepts remain the same, right? So this is one thing which you always keep in mind. Just because there is a bill, new bill coming into place, ये अभी लॉ नहीं है, दिस इज जस्ट अ बिल. इनफैक्ट ये बिल इंट्रोड्यूस हुआ है, उसके बाद दिस इज द पार्लियामेंट्री स्टैंडिंग कमिटी, you know, where they are currently examining the bill, क्या changes जो होने चाहिए इसमें, if there are any recommendations, they are still working on it, right? So that's one thing. That is your IPC. The next thing is your CRPC, that's your Code of Criminal Procedure. That has been renamed as Bharatiya Nagrik Suraksha Sanhita. तो अब ये CRPC क्या प्रोवाइड करता है? ये हमारा प्रोसीजरल लॉ होता है, राइट? सो दिस टेल्स यू व्हाट इज द प्रोसीजर फॉर फाइलिंग a criminal case and how the police is going to investigate. पूरा का पूरा investigation procedure जो होगा वो कैसे होगा, that is given under the CRPC. Now CRPC has seen some major changes so far as the Bharatiya Nagrik Suraksha Sanhita bill is concerned, especially, you know, इसका बहुत digitalization technicalized, you know, it has been, a lot of technology has been introduced even when it comes down to the police. Like police ko jab aap baat kar rahe ho under the CRPC, they are supposed to not only have, if you file an FIR or if there is a complaint being filed in the police station, so not only will they have to maintain a hard copy in their registers, jo wo hamesha se karte aa rahe hain, but they'll have to have digital portals, you know, even let's say there is a diary entry. एक नॉर्मली हम सुनते हैं एक टर्म FIR, फर्स्ट इंफॉर्मेशन रिपोर्ट, जो पुलिस के पास आप फाइल करते हो, बट इवन बिफोर द FIR इज फाइल्ड, पहले जब आप सबसे पहले जाके पुलिस में, यू नो, यू फाइल अ रिपोर्ट, देयर इज समथिंग नोन एज अ डायरी एंट्री व्हिच इज मेड बाय द पुलिस. सो द CRPC टू द एक्सटेंट सेज कि जो DD एंट्री होती है, डायरी एंट्री होती है, इसका भी डिजिटलाइज्ड वर्जन होना चाहिए. सो इट्स एवरीथिंग, ऑल द इंफॉर्मेशन हैज टू बी अवेलेबल ऑनलाइन as well, right? So basic idea is transparency leke aana, right? So there are a lot of changes which have been made in the CRPC also, generally with respect to this. And of course, you know, the time, they've given time periods also, time frame reduce kiya hai ki charge sheet kitne time mein file honi chahiye, kitna time police ko investigation ke liye milega. So there are time frames and all which have been allotted. So basic idea, changes have been made to the CRPC also, and now it is known as the Bharatiya Nagrik Suraksha Sanhita. हाँ, of course, ये again like the IPC, it is not as the पूरा हमारा criminal law का procedure ही बदल गया है. That is not the case, but certain changes have been made, right? So that's your second one. The third one is your Indian Evidence Act. Now this is the one which we will be talking in a little more detail in today's class. Now the Indian Evidence जो Act है, ये change करके इसका नाम कर दिया है भारतीय साक्ष्य बिल. राइट, अब भारतीय साक्ष्य बिल, साक्ष्य बेसिक होता है प्रमाण, प्रमाण इज एविडेंस, राइट? तो ये जो bill hai, ye, this again talking about the how evidence is going to be brought, what is admissible, what is not admissible, all those things are covered, which were covered in the Indian Evidence Act, have been covered in the Bharatiya Sakshya Bill. Abhi jo Bharatiya Sakshya Bill hai, ye bill jo hai, isme, you know, I feel the least number of changes have been made in this bill. You know, majorly जो पुराना हमारा एविडेंस एक्ट चल रहा था 1872 का, majorly that evidence act still is there. there have been few changes, especially when it comes down to electronic evidence, because again, technology को, to bring technological advances into the purview of these acts, कि कैसे जो changes हुए हैं technology में, how are they affecting our justice system, all in order to cater to those advancements, ये हमारी जो Evidence Act है, इसमें भी changes लाए गए हैं. So most of the changes, in fact, in the Indian Evidence Act are vis-a-vis when you talk of the these electronic, evidence and all that, right? Electronic records, electronic evidence, उसके ऊपर आपके key changes हैं. ठीक? Now, this is a basic outline about the 3 acts which are there. Now, the reasons as to why these have been, these new acts have come around, because there are a lot of criticism of the government कि भाई क्या जरूरत थी, आप amendment करके भी ये change कर सकते थे. Why do you need to bring about a new law? So, there have been various reasons have been given by the government कि भाई ये बहुत पुराने act हैं इनके, and not only, when you're talking about some of the changes which have been made, some of the changes are such कि वो कुछ colonial era के remnants हैं जो इन acts में है. जैसे Evidence Act जो है उसमें कुछ चीजें लिखी हैं कि, things like that, what can be treated as evidence and all, something which is given by the Queen or something which is, presented in the British courts and all that, तो वो सारी जो evidence से related चीजें हैं वो अब delete कर दी गई हैं Evidence Act से, right? So basically they are trying to declutter or so-called decolonization of our major criminal laws in the country has also happened. Another angle, भाई क्यों करा गया है, बोलते हैं कि ये जो सारा logic था, or what was the basic premise behind the 3 laws was always to give punishment. No, because end of the day, if you look at the Indian Penal Code, penal का मतलब है punishment, कि India का punishment का code क्या है, right? So इसीलिए जब इसका नाम change किया, they said no, we are not looking at it as a punishment, but rather we are looking at it from the point of view of justice, कि भाई न्याय हमारा criminal justice system है. Our system is not criminal punishment system. Right, so the perspective has to be such that the idea behind the criminal system is not to give punishment, rather to provide justice, right? Because obviously Britishers का justice provide करने में तो कोई interest नहीं था हमारे यहाँ, but हाँ, punishment provide करने में जरूर था, right? So that is why it was the Indian Penal Code, whereas what we have named it now as is Bharatiya Nyay Sanhita, मतलब Indian Justice Code, right? तो हमारा justice से related है. Similarly, CRPC is not just criminal procedure, rather it says भारतीय नागरिक सुरक्षा संहिता, right? So हमारा ये जो bill है, ये हमारी नागरिक की, citizen की protection के लिए है, right? That is the basic idea. Sakshya is simple, Sakshya is evidence, so that is what it remains as, right? So this is a brief on the 3 codes which have been brought about. Now let's come down to the Bharatiya Sakshya Bill specifically. Now when you look at the Bharatiya Sakshya Bill mein, like I said, not too many changes have been made, right? Now it retains several parts of the act. In fact, jo basic iska to jo index hai, index change hua hai, but they haven't really changed much so far as the parts are also concerned. Broadly the Indian Evidence Act was always divided into 3 parts. Okay, there were 3 parts so far as the Indian Evidence Act was concerned. First was to check whether the fact is relevant or not. So that was known as the relevancy of facts. Then there was a part which deals with on proof, what can or how proof, how do you prove a thing? So it was supposed to be on proof. And the last one was production of evidence, as to how do you bring an evidence. So like, secondary evidence, primary evidence, how do you bring about evidence? So ye jo basic structure tha, this structure is almost the same. Unlike the IPC and all, jahan pe pura restructure kar diya hai in Bharatiya Nyay Sanhita, whereas एविडेंस में इतनी रिस्ट्रक्चरिंग नहीं हुई है. 3 की जगह इन्होंने 4 कर दिया है. जो फर्स्ट 2 डेफिनेशन टाइप के क्लॉजेस थे उसको उन्होंने प्रिलिमिनरी क्लॉज कर दिया है, एंड रेस्ट ऑफ द एक्ट बेसिकली रिमेन्स द सेम. सम 23 odd provisions have been amended, have been changed, and 5 odd have been removed, 1 has been added, right? So not too much of change that we see so far as the Bharatiya Sakshya Bill is concerned. Important changes कहाँ हुए हैं? Firstly, ये colonial references जो थे कुछ act में वो हटा दिए गए हैं. They have been removed. This is the major thing which has been added when it talk about electronic records. Now, electronic records, it is not as though prior to the bill, electronic records nahi the. Electronic records were very much a part of, when you're looking at the bill, when you're looking at the Evidence Act, 2000 में जब हमारा Information Technology Act आया था, if you look at the IT Act, when it came in the year 2000, that is the time when, that is the time when you would realize that, the provisions regarding electronic evidence had been added. Right? So it is not as though bill, ye wale Sanhita bill se pehle hamare paas electronic evidence was not accepted as evidence at all in our country. It was very much a part of evidence, but the only thing was that ye wale bill mein it has been given a little more clarity. And in fact, there was this judgment. This is known as the Arjun Pandit Rao versus Kailash Kushan Rao judgment. ये एक बहुत ही important judgment है on principles relating to electronic evidence कि भाई electronic evidence जो है कैसे, how it is going to be considered as evidence, what all would be considered as evidence. So they had laid down certain broad guidelines, right? Certain broad guidelines had been laid down on electronic devices, on electronic evidence, right? So this particular जो हमारा अभी bill में changes आया है with respect to the electronic devices, you would realize majorly the position which was in the laid down in this particular judgment is what has been it's kind of cemented. So earlier it was basically because of the amendments which were made, and then there were these judgments which had come in, and this judgment is what has been cemented further by this law. कुछ चीजें हैं जो change हुई हैं. We will discuss them by way of passage which we have here. But what you have to realize is that majorly it's quite the same. Now there is a clarity. When you talk of evidence, evidence law में क्या होता है? Evidence primary evidence भी होता है, and evidence एक concept होता है secondary evidence का. Okay. Now, when you talk of the Indian Evidence Act में हम बोलते हैं evidence जो है आप documentary evidence देते हो, आप oral evidence देते हो. जब आप documentary evidence देते हो, in documentary evidence, evidence is normally prior to all this electronic data and all coming in, electronic documentation coming in, it was always in the form of a paper. Right? So if it's an original of a paper, it was considered as a primary evidence. तो अगर मेरा कोई sale deed है, तो वो sale deed का जो original document है, that I can submit as evidence in the court, that will be considered as primary evidence. Whereas if I am giving a photocopy of that particular document, let's say the sale deed itself, I want to prove that this property is mine. So I'm providing a sale deed का photocopy in the court. तो जब मैं sale deed की photocopy provide करती हूँ court में, तो उसको हम secondary evidence बोलते हैं. Secondary evidence is not the main original evidence, but it is something which will help you prove your case, right? So in fact, it is said that, when you are talking about secondary evidence, the secondary evidence has to be corroborated with some oral evidence, right? So if I am bringing this secondary evidence, I'll have to prove कि okay, ये मेरा secondary evidence है, इसके contents जो हैं, ये हैं, right? So along with my oral evidence, I bring in my secondary evidence. On the other hand, primary evidence को कोई corroboration नहीं चाहिए होता. Primary evidence आपका primary evidence है, original है, आप original submit करोगे court में, and that acts as evidence on the basis of which a judgment can be given, right? Now, when you look at इलेक्ट्रॉनिक रिकॉर्ड्स, ओरिजिनली जब ये जजमेंट, ये हमारा अमेंडमेंट्स वगैरह आए थे इन 2000 एंड दे वांटेड टू इनकॉर्पोरेट प्रोविजंस रिगार्डिंग इलेक्ट्रॉनिक रिकॉर्ड्स, it was supposed to be that and if you want to bring it as evidence, let's say there is an electronic record on a laptop, then you had to bring the laptop itself to the court. Right? So if you want to prove that there is, let's say, an email which was sent to me, so I'll have to bring the laptop and show that particular thing. Or if there's any kind of document, I have to show it on the machine itself, right? And if I take an output out of it. If I take let's say a printout out of it, it was considered as secondary evidence, right? So this was there prior to the amendments. Then post 2000, once the amendments were made, this thing was changed. What did they do? They said that even if you're taking a printout, even when you take a printout, that printout is going to act as a primary evidence only, right? It will not be considered as a secondary evidence. It is not as though you are making a photocopy out of it, but every printout or every output of that particular document from the machine is going to be considered as a primary evidence itself, right? So it's as good as an original, right? So whether it's an email, it's a message, or any kind of, so in fact, not only printout, even if you put it in a USB device or any kind of magnetic device, any kind of storage device, if you put it, that itself becomes a primary evidence, right? So all these things had been existing even prior to this bill. So somehow, sometimes you feel, there's a lot of claim by the government that by this we are going to bring in electronic evidence. That is true, and it's not completely true. There are certain changes which have been brought about, but because of this 2000 amendment, a lot of it has already been going on in the country, right? A little bit here and there, we'll understand what has been brought about in the next passage. But idea ye hamesha yaad rakhna, primary, secondary, this is always generally a little confusing. So this is something which you keep in mind. Okay. Now this is something which has been I've picked up from the bill itself. Now, what does it say? This is when you're talking explanation, clarify as to what all is to be considered as primary evidence when dealing with electronic record, right? It says, nothing in this adhiniyam shall apply to deny the admissibility of an electronic or digital record in evidence on the ground that it is an electronic or digital record, and such record shall have the same legal effect and validity and enforceability as paper records. So here, this is something which was missing from the previous act. This is a clarification which has been very specifically added कि भाई अगर आपने electronic record दिया है, then it is going to have the same validity as if it was a paper record. So this is, basically what the government is trying to do by this act is they're trying to reinforce the fact that, okay, there should not be any doubt in anybody's mind when it comes down to the validity of electronic records as primary evidence, right? Okay, now these are some of the basic things that are there so far as this act is concerned. Now, what I have here today after this is one passage which is also talking about which is based on the new bill, Bharatiya Sakshya Bill. So what I would want you to do, guys, to do is go through the passage, and then I have about 4 odd questions on the basis of that passage. So let's go ahead and solve those passages. If you have any doubts in the meanwhile, you can always put it in the chat box, right? Now, let me show you the passage which is here. Just a minute. Just 1 minute, guys. I will just 1 minute. Seems to be an error in the. I will just be showing the passage in a minute to you. Just 1 minute. Slight technical hitch with my PPT. In the meanwhile, those of you who have any doubts on what we've done till now, please put it in the chat box. I would be more than happy to take it for you. just wanted the passage to be a little more legible, since all of you would be reading in the screen, and I thought it should be put in one slide, just making it slightly bigger for everybody to be in a position to read it. Oh, I think this is better, little more legible for everybody. Here it is. I think now it is visible to everybody. This is the passage. Now I want all of you to please go through the passage, and then we'll discuss the questions on it. Okay. So I'll give you guys 5 minutes to go through the passage, please. Okay. Now let's quickly discuss the passage. I'm hoping all of you have been able to go through the passage. We'll have one last minute. Okay, so let's understand now. Now, let's see what this passage is basically talking about. Now, if you look at the passage, this passage is telling us, now, whenever you're reading the passage, one of the first things that you always do is you mark, or you have to zero down on what is the principle, right? What are the basic laws involved in it, and what could be acting as a principle for a question? Because end of the day, the reason why this passage is given to you, or why you are reading the passage, is to mark your answers on the basis of the principles. So whenever you're reading the passage, always the first thing that you do is try to cull out, try to mark what is the principle, which could be the basis of your answer, right? Now, here when you start, the first part is okay, there's nothing much. The Act provides for rules of admissibility. That's perfectly fine. Then it says, Act provides for two kinds of evidence. Okay, so this is one thing you keep in mind. Evidence can be of two kinds. It could be oral or it could be test or it could be documentary, right? So that is one thing you keep in your mind. Then it goes on to say oral would include information in electronic records that have been printed or stored in magnetic media produced by a computer. So this is something essential, which means that normally when we think of electronic records, we would think of something which is in an electronic device, right? You would think of something which is in a computer, in a phone, or any kind of electronic device. But something which is printed is also considered as an electronic record, right? So this is something which is essential. Or if it is stored in a magnetic media produced by a computer. So basically you're talking about USBs, you're talking about CDs, DVDs, all those are something which is considered inside this. Now then it says such information may have been stored or processed by a combination of computers or different computers. Fine. So it is not there's only one computer, more than one. Perfectly fine. Then it says the bill provides the electronic or digital records will have the same effect as paper records. Now, this is exactly the part I had also mentioned in the previous slide, that electronic records will have the same legal effects as paper record, right? So the same thing as a paper record is going to be the electronic or digital record. Then it says it expands electronic records to include information stored in semiconductor memory or communication devices. So whether it is a smartphone or it is a laptop or any other kind of an communication device, in all those things, so whether it's a tab or maybe sometimes even a smart watch now, all of these would be included in your communication devices, right? So the definition here has been broadened, and it also includes records on emails, server logs, smartphones, locational devices, voicemails. So here the definition has been broadened a little. So that is something which you have to keep in mind. Then it says, as per the bill, the information may have been created or stored in or processed by one or more computers. Now here again, it is talking about either it could be a standalone system or a computer network or through an intermediary. Now, intermediary is something which has been in news a lot. Intermediary is basically when we are talking about, the internet. So through the internet, when you're talking about, whether it's your Insta, whether it's your Twitter, it's your Facebook, all those, any kind of social media basically is where the intermediary comes into play, right? So here, even if it is either on a computer system, where we're talking about a hard, basically when we're talking about hardware, or it could even be via intermediary. So when we're talking about cloud system, when we're talking about social media, even if it is stored by an intermediary, that could also act as evidence, right? That can also be brought about as evidence. Now, this is something which is important considering how the role this is playing nowadays in, especially things which are in news a lot. There is a lot on sedition nowadays, a lot on hate speech nowadays. So ये सारी चीजें जो हैं, ये बहुत सारी चीजें आपकी intermediary के through on the internet होता है, right? So therefore, these things become very, very important pertaining to the present times, right? Then it says, under the Act, oral evidence includes statements before the court made by witnesses in relation to fact under inquiry. अब oral evidence, जो originally हम oral evidence को बोलते थे, oral evidence used to be if you're standing before a judge, right? Originally Act के हिसाब से अगर आप बोल रहे हो कि this is considered as oral evidence, then if you're standing in the court, जैसे वो पिक्चरों में नहीं दिखाते तारीख के टाइम आप कटघरे में खड़े होते हो. So if you're standing there in the court and you're giving evidence on a fact, then that will be considered as oral evidence. Any other kind of evidence would be considered as documentary evidence. But यहाँ पे, what is the major change which the bill has added? It says that even information given electronically will be considered as an oral evidence. That means if it is information given, let's say over the phone, or information given in electronic form, that will also be considered as oral evidence, right? This is a change. This was not there previously. This is something which has been brought about with the new bill, right? So ये एक और point है आपका यहाँ पे जो नया है, and today when we are reading about it, we are not only reading about it from the perspective of the passage, which we are also reading about it from the perspective कि क्या नई चीज add करी गई है, via this bill. So this is something which is different. One should keep note of. नेक्स्ट चीज क्या यहाँ पे इस पैसेज में है, then it says under the act documentary evidence includes primary and secondary. That's perfectly fine. Then it says primary evidence includes original documents and its parts. So when you are talking about evidence, primary evidence would be not only the the main document, but if there are any parts of it, that would also be considered as primary, right? So both are considered as primary, because sometimes hota hai koi document hai that's not just in one piece, like let's say the sale deed ka kuch annexures bhi honge, so those annexures are those parts, right? Then it says such as electronic records and video records. And so primary evidence would not only include the documents, but electronic records, video recordings, so they would also be considered as primary evidence, right? Now, then it is talking about secondary evidence. Now, secondary evidence ke mamle mein, there have been certain changes which have been brought about in the bill. So let's understand what they are. Now, secondary evidence contains documents that can prove the contents of the original. So here we are not talking about the document in original, but a document by which you can actually prove what is given in the original document. So you're trying to prove the contents of the original document. Now it includes copies of original and oral accounts of documents contents. Now sometimes even an oral account of a document content can be considered as secondary evidence. Ab law mein, evidence law mein iska hota use kaise hota hai usually? Let's say I don't have a copy of the original document, or the original document is missing. Then a lot of times court will allow a person to give oral evidence about a document that he has seen. So let's say I say that yes, I had seen the sale deed, मैंने वो sale witness करी थी और मैंने sale deed पढ़ी है. So I think got disconnected. Okay, so yes, so we were on secondary evidence. So when you look at secondary evidence, yeah, a little bit of disconnection. Sometimes the internet gives trouble. I think everybody witnesses that, right? Okay. So ab yahan pe aaya secondary evidence. Ab secondary evidence ke bare mein, what is it that the bill is saying? Now, what bill has done is the new bill has expanded secondary evidence to include oral and written submissions, testimony of a person who has examined the document and is skilled in the examination of the document. So here it says that not only are we talking about photocopies and oral submissions, but even written submissions. So earlier, if the oral submissions were there, then they had to be corroborated with a written document. Right, with the written document, you had to compare ki bhai oral ye bola hai, and you have some sort of a documentary evidence to support it, and then there is a corroboration, and there is sort of a, you try to bring the two together. But now with the change, they have said even oral submissions or written submissions of a document, we don't have the document is missing completely. But if I just tell that, okay, I had seen this document and this is what the document was about, that would be taken as evidence, right? And similarly, they're talking about written admissions also. So in writing, if I give that, yes, this is a document I have seen, this is something, this is what the contents of the document is, right? So this is something which is a sea change, because earlier, agar secondary, अगर डॉक्यूमेंट नहीं है तो सेकेंडरी एविडेंस में एज ओरल एविडेंस अगर आप उसको लेके आ रहे हो, इट ऑलवेज हैड टू बी corroborated. उसको हमेशा ओरिजिनल डॉक्यूमेंट से या किसी फोटोकॉपी से corroboration की जरूरत होती थी. Only then it could be considered. But now they have considered it to be only oral evidence is also included in this bill. Right? This is something which has seen some criticism. Ki bhai aise to, this might open floodgates. This might not be a very good thing. So let's see how, how it plays out, what is going to be the interpretation of this, whether this really remains in the main act or not, right? But this is something which has been a new thing which has been added. Another thing it says is testimony of a person who has examined the documents and is skilled in the examination of the documents, right? So here it's basically talking about if it's a document, it's a technical document. So somebody who is kind of skilled in that particular type of document, then his evidence would also be taken into account as secondary evidence, right? Then it says under the Act, secondary evidence may be required under various conditions, such as when the original is in possession of the person against whom the document is sought to be produced, or it is destroyed, right? Now here, what does the bill add? The bill adds that secondary evidence may be required if the genuineness of the document is itself in question. So earlier they said that when do you need to bring in secondary evidence? You need to bring in secondary evidence first if it is in the possession of the person against whom it is being proved, right? So let's say I am supposedly in the possession of the document, okay, and you want to prove the document against me, then you can bring in secondary evidence, right? Secondly, it says is that if it has been destroyed, the primary evidence of the document is not there anymore, that is the time when you can bring in secondary evidence. But the new bill is adding one more requirement. What is it saying? It is saying that the genuineness of the document is in question, which means you are questioning whether this document itself, so what document primary evidence जैसा लेकर आए हो, but you are questioning कि भाई ये document जो आप लेकर आए हो, is it really a genuine document, authentic document, right? So that is when secondary evidence comes into play, right? When the court, let's say, is unsure whether this document which has been brought in is really a genuine document or not. That's again something new which is being added so far as this act is concerned, right? So this is what the passage was about. Now let's quickly do the questions which are there under this passage. Okay, let's move on to the first question. Now, when I look at the first question, what is the first question talking about? Now, the first question is talking about a dispute between two cousins, right? So there's a dispute which is happening between two distinct cousins where they are talking of there's a dispute about a property left by the uncle. So here the question here is both of them have not been able to bring the will, but Lata has somehow managed to get a photocopy of the will, right? So the question here is, will the court admit the photocopy as evidence? Now, firstly, if you look at what we just read in the passage, photocopy can be brought as evidence, right? But what kind of evidence? It cannot be primary evidence. It has to be a secondary evidence, right? So when I look at the options which are there in front of us, what do we have? The first option says the court will not admit the copy as primary evidence because it is not the original will. Now, this looks decent because so far as the court is concerned, it is surely not going to be admitted as a primary evidence, right? Because it's a photocopy. It's only if it's an original will it be considered as a primary evidence. So this looks okay. We can keep it open. Now, when you look at the second option, and the second option says the court will admit the photocopy as secondary evidence. Is this correct? Looks okay, yes, because it's not the original will, but it is a photocopy. Copies can be admitted as secondary evidence. So B could be your answer. Looks decent again. C says the court will admit the photocopy as primary evidence. Now this you know for sure is incorrect because photocopy can never be a primary evidence. Primary evidence has to be the original document, right? So you know C goes out. D says court will admit the photocopy as secondary evidence because it is not the original will. Now here, this out of all the options which are given, which now all of them, A, B, and D, all of them look correct, right? It's not like, you can't really say any of them is incorrect. This is where the generally the quandary or the confusion of a legal reasoning question is that option सारे सही लग रहे हैं, but इन सब में हमारा सबसे correct option कौन सा है? Now, when I look at the question which is in, अगर आपको ऐसा confusion होता है, the first thing that you do is you look at the question. And when you're looking at the question here is, will the court admit the photocopy as evidence? The answer has to be a yes, right? The court will admit the photocopy as evidence. Of course, not as primary evidence, but it will be admitted as secondary evidence. Therefore, an option A, which is talking about it only in the form of primary evidence, should not be your correct answer. ये आंसर आपका तब सही होगा अगर आपके कोई भी और ऑप्शन सेकेंडरी एविडेंस या उसको एडमिट करने की बात नहीं कर रहे, राइट? सो इंस्टेड ऑफ हैविंग इट इन अ नेगेटिव मैनर, इट्स रादर यू हैव इट इन अ पॉजिटिव मैनर, राइट? Because if you just mark A, तो वो position को उल्टा बताता है. That means it cannot be admitted. Right? A is out. Now B says the court will admit the photocopy as secondary evidence. This looks good. Yes, it would be admitted as secondary evidence. And then you have option D, which says will admit the photocopy as secondary evidence because it is not the original will. Now, if it were the original will, it would have been accepted as primary evidence. So between B and D, the best answer would be D because it is giving you an explanation along with the fact that what it will be admitted as, right? So between B and D, D would be better. It gives you a better explanation. B is not giving you an explanation, right? So this is where we come down and zone in on option D. Take. Let's move forward to the next question. Now, in the next question, it says, now, same fact situations, we are continuing. It says in the above question, presume that neither of them has the will, but Raghav claims that his uncle had sent him messages on the mobile. अब वो जो लता के पास photocopy थी, वो भी हमारे पास नहीं है, right? We don't have anything, but there are messages on the mobile. Now, so when it comes down to messages on the mobile, can they be produced as evidence to prove this? Because he says there are messages and uncle has even mentioned that there is a will to this effect. Now, can these messages be brought as evidence or not? Now, when you look at the options, option A says Raghav's mobile phone can be presented as evidence, which is true. It can be presented as primary evidence. We know that. B says printout of messages on Raghav's mobile can be presented as evidence. Is that also correct? Yes, that is also something which is correct, right? Because we know that when it comes down to printouts, very specifically in the passage also, it is written that each electronic device and printouts of that electronic device, both of them are considered to be as evidence, right? So both of them would be considered. So both A and B are, both of them look correct. C says USB device containing messages. Now this is again, magnetic device in which you stored the messages. That is also something which can be brought as evidence, and this will be considered as primary evidence, right? Like original. So all three of them are correct. Hence your answer is going to be option D, all the above, right? This is fairly simple, but basically bringing out the point कि किसी भी type में का form हो, all of them works as evidence, right? Now, the next question, let's move on to. Now, the next question is talking about which of the following would be true about the nature of evidence brought in the above case, right? So when you're talking about Raghav's mobile phone will be considered as primary evidence. Is this correct? Yes, it's his device itself. The device in which the message has been delivered, that is going to be considered as primary. What about the printouts of the messages? Will the printouts be considered as secondary? Since, they are not the original messages, but they are printouts of the same. Would they be considered as secondary or would they be considered as primary only? Now, if you look at the passage क्या बोलता है? Passage बोल रहा है कि भाई अगर इलेक्ट्रॉनिक डिवाइस है तो चाहे आप उसका प्रिंट आउट लो, चाहे आप उसको कहीं स्टोर करके रखो, चाहे आपने एक कंप्यूटर से लिया है, चाहे आपने बहुत सारे कंप्यूटर से लिया है, in all those scenarios, it is still going to be considered as primary evidence, right? In fact, this is something which has been specifically been mentioned about in the new bill also, right? ये जितना भी evidence होगा, electronic evidence, including printouts, are always considered as primary evidence. Therefore, ये जो है correct situation नहीं हो सकती, whereas this here is your correct situation, right? So answer here is going to be option A. Both cannot be there and neither is also incorrect. So correct answer is option A. Take, let's move forward. Now we have the last question. Now when I look at the last question, or what does the last question say? Says what can be inferred from the passage with regard to the Bharatiya Sakshya Bill, right? Abhi Bharatiya Sakshya Bill ke liye aap infer kya kar sakte ho? First one says Bharatiya Sakshya Bill aims at amending the Indian Evidence Act. Now, is this statement correct? Are they amending the Indian Evidence Act? They're not just amending, what they're doing is leading to amendment of the Indian Evidence Act, but by way of this bill, they are not amending the Indian Evidence Act. What are they doing? They are replacing the Indian Evidence Act, right? So to say that they're amending the Indian Evidence Act by the bill would be something which is incorrect. So for sure, this is not something which you can infer from the passage. B says, prior to the bill, electronic records were not admissible as evidence. Is this correct? Were they not admissible as evidence? No. We just read that even though, if you look at the passage also, passage talks about the act including electronic records as evidence. So when the passage is talking about the act includes electronic records of evidence, which means that even prior to the bill coming into play, that electronic records were admissible as evidence. So this is not something which you can. Now here, it's not always that because of prior knowledge that you have come to this, because all of you must be thinking, of course, there is this 2000 amendment to the Indian Evidence Act, which was brought along with the IT Act. So of course, electronic records were always admitted, even though prior to this bill. But always remember, you have to look at it from this passage perspective. But so far as the passage is also concerned, there also, how do you come to know? Because passage में बात हो रही है act की. तो पैसेज में जहां एक्ट मेंशन करके चीजें दी गई हैं, that means they're not talking about the bill there. Keep that in mind. In the particular passage that we just read, wherever the word act was mentioned or anything about the act was mentioned, they are talking about the Indian Evidence Act there, right? They're not talking about the provisions of the bill. And when they are talking about electronic records, they're mentioning there the word act, right? So therefore, from the passage also you can make out that prior to the bill, electronic records were admissible as evidence, right? So this is something which is incorrect. Last C option, now we have oral evidence can be given only in electronic form. Now, this word only makes it too extreme. Of course, the bill says that oral evidence can be given in electronic form. Right? So, और electronic form में जो evidence है, उसको हम oral evidence consider करेंगे. But not vice versa that oral evidence is only in electronic form. Oral evidence अभी भी वो आप कटघरे में खड़े होके जो evidence दोगे court में जाके, that will also be considered as oral evidence. But something which you give in an electronic form would also can be considered as oral evidence. This is something which is which has really come into play because of COVID also. In COVID, what happened? These proceedings and all were happening all via the internet, right? So you had proceedings which were taking place online. So, all Supreme Court matters, High Court matters, the hearings were happening online. The witnesses were giving their statements online. So, जब वो online statement दे रहे हो, तो obviously आप जज के सामने कटहरे में तो नहीं खड़े हो, but it is happening through an electronic form, right? So happening through an electronic device and was considered as oral evidence, right? So that has been given, a more clearer form via the New Evidence Act, right? So oral evidence is not the only, but yes, it can be, right? So therefore, C is too extreme, so cannot be inferred. So answer here is going to be D, none of the above. None of them can be inferred from the passage, right? Chalo. Now this is so far as your passage is concerned. I hope you're able to understand the basics of the Indian Evidence Act, or the basics of the Bharatiya Sakshya Bill now, because Bharatiya Sakshya Bill jo hai wo bahut news mein hai. Apart from this, there are certain other concepts which are important so far as the Sakshya Bill is concerned. Aaj ka hamara jo passage tha, that was basically on electronic records, and it was on primary and secondary evidence. There is one more topic I would want to quickly make you privy to it, जो कि ये bill के बारे में थोड़ा सा important है. That is the law on confessions. The law on confessions, I'm sure all of you are preparing for CLAT are aware confession is valid only if it is made before a magistrate, right? Especially जब हम confession police के सामने की बात करते हैं, before a police officer, or not just police officer. Remember, when we're talking about confession before a police officer are not valid, and also confession before police custody. So if somebody is in the custody of police, or somebody confesses before a police officer, both these confessions are considered to be invalid. They are not considered to be valid in law, right? They are invalid का मतलब हो जाता है कि इस confession के ऊपर आप अपना you cannot give a judgment on the basis of this confession. This confession cannot be used as evidence, right? अब ये जो हमारा bill है नया, ये continue तो यही चीज करता है, right? So whatever was there in the Indian Evidence Act regarding confession, the same thing is continued in the new act. The only thing is, in the prior act, previous act, in the Indian Evidence Act, there was this provision also regarding confessions, which spoke about something known as, when you're talking about evidence, it is not just evidence, but even though the confession could not be taken and the confession could not be the basis of your judgment, but you could take certain kind of information from it, and this information could then be used to discover. This was known as the power of discovery. So if, let's say, there is a murder weapon which was missing. So while a confession was being made before a police officer or a person in custody, then what happened was that in this entire story, that when he's confessing his crime, he tells that yes, I hid the murder weapon there. So this discovery of object, this is something which could be used as evidence. That, in his statement, we are not talking about that confession usne kiya hai, but he did tell us that, in under that mango tree behind his house, he has hidden the knife with which he killed the person, right? उसने एक का murder किया और अब घर के पीछे आम के पेड़ के नीचे उसने वो murder weapon जो है छुपाया हुआ है. The police actually go ahead and are able to find that murder weapon there. Then they can use that statement which they made. That's a discovery which they made in the when they are trying to prove their case before the court, right? So ये जो discovery वाला angle था, this was available in both the cases. चाहे confession before the police officer हो, चाहे it is confession in police custody. Now, what they have done is, under the new law, they have kind of restricted this to confession only in police custody, right? And not for police officer. Now, there is two schools of thought here. Firstly, they're thinking that maybe this is actually a smart move on the part of the government, where, because end of the day, why is it आप confession before police officer या before custody में आप क्यों नहीं allow करते हो? You don't allow it because of the simple fact that, अगर आपने ये confession allow कर दिया, then there will always be more violence. पुलिस जो है वो डंडे के जोर पे वायलेंस करके confessions निकलवाएगी, and people would be then going behind the bars. So in order to stop custodial violence and to ensure the safety of the under trials जो accused है, all this was supposed to be a deterrence, right? So if you are saying कि पुलिस कस्टडी वाला होगा, पुलिस ऑफिसर को ये पावर नहीं दे रहे, so somewhere the other you're trying to make it even lesser, right? Because end of the day, जब ये डिस्कवरी वाला एंगल आप डालते हो, डिस्कवरी वाले एंगल से क्या होता है, आप इन अ वे पुलिस को एनकरेज ही कर रहे हो कि हाँ भाई थोड़ा बहुत वायलेंस यूज कर लो, कि क्या पता जब तुम कन्फेशन ले रहे हो, कन्फेशन नहीं पर डिस्कवरी माइट जस्ट स्टिल वर्क, राइट? सो दे बाय लिमिटिंग this discovery in a way. There is this limiting in violence or limiting in police torture or something is being, is what the thought is. But the other thought is कि भाई जो Indian Evidence Act थी, हमारी जो पूरी act बनाई है, इसकी drafting पे भी बहुत सवाल उठे हैं. There are certain provisions in which the drafting of this entire new bill is a little lax. कुछ चीजें हैं, कुछ जगह अपने प्रोवाइजोस दिए हैं, जैसे सेक्शन 165 है, उसका अपने प्रोवाइजो दे रखा है, वो प्रोवाइजो वहां सूट नहीं करता है, कहीं और जाना चाहिए. So there are certain little lacunas which is there in so far as drafting is concerned. So there's another school of thought which says कि भाई ये जो इन्होंने प्रोवाइजो या इन्होंने जो ये डिस्कवरी वाला सिर्फ पुलिस कस्टडी को दिया है, कहीं ये गलती तो नहीं हो गई है इनसे, कहीं ये दोनों को देना चाहते थे, but because of error in drafting this has happened. Right? So these are these small little things which are a part of the Indian Evidence Act, and which have now, when they've tried to translate everything into the new bill, try to change the structure a little, तो ये कुछ इनके structural defects जो है वो हैं, drafting के defects जो हैं. So there has been criticism of the way it has been drafted, right? So I am just hoping कि जो parliamentary committee के पास ये गया है bill, they actually streamline a little more, थोड़ा उसका structure को ठीक करेंगे, and all these little nuances which are missing, little things which need to be corrected, and they are more like technical typographical sort of things which need to be corrected, right? So hopefully all that would be done in the coming months, right? So this is so far as the Bharatiya Sakshya Bill is concerned. I'm hoping that you have some clarity on what the bill is all about now, and so far your exam is concerned, you would be able to attempt. Always remember, the CLAT paper here is not there to check your knowledge on law, right? They are there to check your application of it, right? So when you are reading about all these things, always remember, they're not going to give you something which you're not able to comprehend. They will always, if they want you to apply certain principles of law, those principles of law would be explained to you there, right? Now, this is one thing I always want all the CLAT aspirants to keep in mind. So what is really essential for you right now when you're preparing for CLAT is that you read as much as you can, right? So on your Bharatiya Sakshya Bill has been here, it would be a good idea to read about it at your own end. Okay, so that's an advice from me, and I hope the session was useful for all of you who are here today or who watch it later on. Okay, chalo then. Take care, and as usual, we are CLAT Possible. I am Neha. I am the legal mentor here at CLAT Possible, and hope to see you guys soon somewhere, either on any of our social media channels. If you have any trouble in preparing for your CLAT exams, do feel free to get in touch with us. Okay, ciao, bye bye, take care. Thank you so much, guys.